Hey guys, and welcome back. Today we will be discussing caveat under the Civil Procedure Code, as you may have seen from the title of the video. Caveat is a fairly simple topic. It's often seen as short notes in law exams and sometimes even a longer theoretical question. And it's a fairly easy topic to understand as long as it's clearly explained once. So let's get into that explanation. To understand caveat, we need to turn to section 148A of the Civil Procedure Code. Clause 1 of it provides that where an application is expected to be made or has been made in a suit or proceeding instituted or about to be instituted in a court, any person claiming a right to appear before the court on the hearing of such application may lodge a caveat in respect whereof. So, the important thing for us to understand here is that there are two scenarios in which caveat can be lodged. If the suit is already instituted and in that an application is already been made or is expected to be made, then caveat can be lodged. Or if the suit is about to be instituted and in that suit application is expected to be made, then caveat can be lodged. So, it has to be only regarding an application in a suit or proceeding, first of all. And secondly, that suit or proceeding can be in the present, which is already instituted, or it can be in the future that the suit is not instituted and is expected to be instituted. And in such present suit or future suit, an application is either made or is expected to be made. In all of these scenarios, a caveat can be lodged. Now you may ask, by whom can it be lodged? The section further provides that it can be lodged by any person, whether a party to the suit or not, claiming that he or she has a right to appear before the court in such case. So it can be by any third party, it doesn't have to be anyone related to the suit, as long as they're claiming that they have a right to appear before the court in the suit. Now we know in what cases caveat can be lodged and who can file or lodge this caveat. Now once the caveat is lodged, what happens after that? Let's find out. Clause 2 provides that where a caveat has been lodged under section 1, the person by whom the caveat has been lodged shall serve a notice of the caveat by registered post, acknowledgement due on the person whom the application has been or is expected to be made. The caveat is lodged by the caveator, and he lodges the caveat saying that either there is a suit in the present and in this I expect an application is going to be made, or there is an application existing in the suit and I want to be represented. Or he says that I expect a suit will be filed in the future and in that suit an application will be made, and in that application I want to be represented. So whenever this application comes, whether in a present suit or in a future suit, I want to be represented, so give me a notice. But before he becomes entitled to a notice, he has to give a notice that I have lodged a caveat to the person from whom he is expecting this application to be made. So the caveator has to serve a notice on the applicant who is going to file this application or who has already filed this application, saying that whenever you file the application, you have to give me a notice because I am the caveator. Now, the next question is, once the caveat has been filed and the caveator has given the notice to the applicant, what happens next? What will the court do? That is given in clause 3, where after the caveat has been lodged, any application is filed in suit or proceedings, the court shall serve notice of the application to the caveator. Which means that once the caveator has filed this caveat and he says I want to be represented, and after that actually an application has been filed within the next 90 days, in that case the court will serve a notice on the caveator saying, hello, you filed a caveat a little while ago saying that you want to be represented in this application, you were expecting it and you were right, this application has finally come to the court, so come on and tell us what your story is. So the court will give a notice to the caveator that the application has been filed, come and represent your case. In addition to the court telling the caveator to come, the applicant who has filed this application will also have to give notice to the caveator that, hello, Remember the caveat you filed? Regarding that, I have filed an application in the court, and since you filed a caveat, now I have to give you notice. So please come and tell me what your problem was. Why did you file the caveat? What's your story? So the court will send a notice to the caveator, and the applicant will also send a notice to the caveator regarding the application which has been filed in the suit or proceedings. Court will not move further in this application unless the applicant gives an affidavit that the notice has been served on the caveator. So the court gives the notice to the caveator, the applicant gives the notice to the caveator, and then the applicant has to give an affidavit saying, "Hello court, I have given a notice to the caveator. I have told him that I filed this application. If he wants to come, he'll come now." And usually the court will give about 3 days for the caveator to appear and represent his case. The next thing is, what is the time period for which the caveat stays in force? As provided by the section in clause 5, the caveat stays in force for a period of 90 days, which is 90. And if in this 90 days an application is filed, then the court has to give the notice to the caveator, and the applicant also has to give a notice to the caveator that, "Hello, we filed the application." But if in this 90 days no application is filed, then nobody has the duty to inform the caveator. If the application is filed after the 90 days, then no one needs to tell him. It's not their duty anymore because the caveat has expired. And if the caveator still wants to be informed, then he needs to file a fresh caveat for the next 90 days. And finally, the last question. What happens if a caveat has been filed, but nobody tells the caveator that the application was filed in the case? No one informs him, and they just carry on with the case like he'd never filed the caveat. What happens in this case? That unfortunately cannot be done because the court is bound by the caveat, and if the court or the applicant ignores it and they do not inform the caveator, then whatever decree or order is passed, that becomes null and void, my friends. And that is everything you need to know about caveat. Remember all these points, make sure you mention them with headings. And so we hope you enjoyed this video. If you liked it, give us a thumbs up so we can do more CPC videos. If you're liking them, let us know. And don't forget to hit subscribe so you get notified of new videos.